the vice president. They were happy to have TJ criticized all he could tolerate. And unfortunately, we laugh about it now, it's such a historical abomination. Unfortunately, the federal government actually prosecuted people, and juries convicted them, and judges incarcerated them for doing what we broke away from England to have the right to do: criticize or demean the government. That is the first serious assault on civil liberties waged in a formal way by the government. I'm not talking about a runaway sheriff or a crazy FBI agent or a goofy U.S. Marshal or someone who should never have been given the shield and the gun of the government. I'm talking about the power of the federal government aimed and targeted at people who would criticize it. When Jefferson became president and it expired, that is the Alien and Sedition Acts, he basically said, don't even send it to my desk because I'm not going to sign a renewal. He didn't have to say that because by then the anti-federalists, those who believed that our rights were natural, those who believed that the states were sovereign, those who believed that the federal government only had the 17, count them, 17 specific, discrete, unique, precise powers that the Constitution gave it. So by Jefferson saying to people of that mindset, don't send me the Alien and Sedition Acts, it was redundant. He wasn't going to sign it, and they weren't going to send it to him. It expires during his presidency in 1805. My friend Bob Higgs has written a great book called The Warfare State, in which he argues that war is the health of the state, that in times of war, the government gets stronger because we let it do so. The next massive assault on civil liberties comes during the Civil War. Now, I come not to talk about Lincoln. I could talk about him for a month, about the massive violations of the Constitution. When one of Gillespie's people interviewed me and asked me, who is the greatest violator of the Constitution, I said, George W. Bush has shown less fidelity to the Constitution than any president since Abraham Lincoln. And they said, Lincoln? And I said, yes, Lincoln. Lincoln slaughtered 650,000 Americans. Where's the power to do that in the Constitution? Lincoln locked up editors of newspapers in the North, not in the South that was rebelling, but in the North because they criticized him. Lincoln had soldiers break down the door of the house of a Republican congressman from Ohio, Clement Vallandigham, because Vallandigham called Lincoln a monster and a tyrant, which he was, and had him banished to Canada for the balance of the Civil War. And of course, Lincoln, never mind what his soldiers did to women in the South, never mind what they did to banks and courthouses in the South that burnt them down, Lincoln suspended the writ of habeas corpus. Well, habeas corpus has been around since 1215. Since King John reluctantly signed the Magna Carta, he agreed that no matter how powerful the government and no matter how awful its target, the target could always compel the government to bring the target before a neutral judge and justify the target's incarceration. Lincoln, on a whim and by himself, suspended that. In the First World War, the Congress enacted the Espionage Acts. The Espionage Acts, one of which is still extant, makes it a crime to discourage workers in munitions plants from going to work. Hey, Dad, you don't look so good today. Stay home. I'm really saying that because I'm against the war and I want a few thousand fewer bullets manufactured today. A guy by the name of Abe Gitlow is the first target of the government in a very, very famous case because he distributed leaflets that he printed by himself in a tenement in the Lower East Side of Manhattan in which he encouraged munitions workers not to go to work. The leaflets were written in Yiddish. And Mr. Gitlow served 10 years in a federal prison for dropping them out of his window from a Lower East Side tenement. When Alberto Gonzales threatened the New York Times about a year and a half ago, he cited the Espionage Act because it is still a law in your country's law books and mine that would permit the government to prosecute someone who encouraged workers not to produce what the government needs for war. What part of Congress shall make no law did they not understand? In World War II, of course, we had FDR. Put aside the socialist monstrosity that he visited upon us, which is everywhere around this building. He locked up 10,000 Italian Americans and 110,000 Japanese Americans. Not Japanese from Japan or Italians from Italy, but people born in the United States as American as he was because of their ancestry. And the Supreme Court permitted him to do so. His argument was that they were a security threat. So they lost their homes. They were separated from their families. They lost their businesses. They never saw a judge. They never saw a jury. They had no charges preferred against them. Does this sound familiar? He hadn't yet coined the phrase enemy combatant. But they were locked up for the remainder of the war, starting in mid-1942. In 1980, a Republican president, strike that, in 1988, a Republican president and a Democratic Congress would enact the Civil Liberties Act of 1988, which Ronald Reagan happily signed. It condemned the wartime incarcerations of FDR. It declared that it is the policy of the American government never to incarcerate someone on the basis of their race or their religion or their national ancestry. It provided financial compensation for those who were still living. $20,000, big deal, but it was something, and there weren't too many still living. It was the first public apology the government made, and typical of the government, it took it 45 years to apologize for one of the most blatant, obvious violations of human liberty, because a cowed Supreme Court went along with it. Now, all of this brings us into the modern era. While all of this is happening, the Fourth Amendment is still being enforced, meaning, for the most part, if the government wants information about you or from you, it must go to a judge and present evidence of probable cause of a crime. And if the judge agrees, I used to take these applications myself in the living room of my home at 3:30 in the morning. And sometimes they wouldn't tell me everything I needed to know, and I said, goodbye, guys, I'm not signing this search warrant. And sometimes I found out weeks and even years later that they didn't tell me everything, and then I signed documents to invalidate the search warrant that I signed in my home 2 years earlier at 3:30 in the morning. For the most part, this system of following the Fourth Amendment worked, and the government followed it. Until 1977, under the administration of Jimmy Carter, when the country is reeling from Watergate and disgusted with Nixon, and the Congress wants to do something about it. So the Congress wrote the Foreign Intelligence Surveillance Act. You hear about this every day today by its acronym, FISA, F-I-S-A. FISA said that if the target is an agent of a foreign government, then you don't need the probable cause of a crime that the Fourth Amendment required. It's 200 years after the Fourth Amendment becomes law, and the government is officially wearing away at it. It says you only need probable cause that the target is an agent of a foreign government. But even this Congress, disrespectful of the Fourth Amendment as it was, and even Jimmy Carter, as big as he was into big government, nevertheless recognized if some evidence was obtained under one of these FISA warrants, it couldn't be used in a criminal prosecution because it was obtained inconsistent with the Fourth Amendment. The Fourth Amendment requires probable cause of a crime. FISA requires